Thank you very much, my lord, your leadership. I see that my Alonso Musyoka Senior Counsel has departed. But we have listened very carefully to the case of the petitioners.
Yes.
We have given consideration to the submissions as well as to the matters put forward in the amended petition and the supporting affidavits. My lord, the respondent's case is simple and straightforward.
Yes.
In our respectful submission, the petitioners have built their case on the wrong legal foundation. They ask this court to treat this matter as a privatization program falling under the Privatization Act, and simultaneously ask that you treat it as a public procurement matter falling under the Public Procurement and Assets Disposal Act.
Yes.
My lords, both of those acts, at section 4 of each of those acts, exclude the sale of shares from the ambit of those acts. And we have set out the precise provisions in our written submissions. It is difficult to understand why the petitioners choose to ignore the statutory route created by Parliament for the sale of shares in a government-linked corporation. The first duty of this court, therefore, my lord, your ladyships, is to identify the correct statutory route for the sale of these shares. In our respectful submission, that is section 87A of the Public Finance Management Act.
Yes.
Section 87A requires both cabinet approval and approval by resolution of the National Assembly, both of which have been met. So that, my lords, your ladyship, the court does not need to invent a further statutory route when Parliament itself has prescribed the route.
All right.
Therefore, the reference to Section 163 of the Public Procurement and Assets Disposal Act about ordinary disposal of obsolete, unserviceable, or surplus assets is of no assistance to the court, because it is not the route for the sale of a block of shares such as what is before the court. In our submission, once the court comes to the conclusion, as it must, that Section 87A is the proper statutory route, then a lot of what is before the court will fall away.
Yes.
Because, my lord, the petitioners cannot insist on an illegality being perpetrated by the respondents by insisting that the matter falls within a legislative architecture which Parliament itself has deliberately excluded.
Yes, continue.
The next issue we want to deal with, my lord, relates to Treasury's role in revenue raising and Treasury's authority to raise revenue or to mobilize non-tax revenue. The submission has been made that Articles 207 to 214 under Part 3 of the Constitution do not provide for the sale of shares as part of the ways in which government can raise revenue. My lords, that is a superficially attractive argument, but it is again a misconceived argument. Article 209 to 214 regulate taxation, charges, borrowing, guarantees, and public debt. But they do not say that government may never raise revenue from an investment. Indeed, my lords, all the court has to do is to go one article down, Article 206, which relates or recognizes that money raised or received by or on behalf of the national government may or should ordinarily be deposited in the consolidated fund unless a statute prescribes otherwise. Why would Article 206 provide or recognize money raised or received by or on behalf of the national government unless the Constitution itself allowed the government to raise revenue other than through taxation?
Yes, continue, John.
Article 206, my lord, is then given life or architecture by the Public Finance Management Act. Sections 11 and 12 of that act then give the Treasury the mandate to formulate macroeconomic policy, to manage public debt, to mobilize resources, and to manage public finances. If the petitioner's construction of the Constitution, limited to Articles 207 to 214, was to be accepted, then it would render Section 87A of the Public Finance Management Act completely meaningless and would significantly erode Article 206, which itself recognizes that government may raise revenue. As my lord, your ladyship will appreciate, the Constitution requires us to give a purposive interpretation to its provisions, not an interpretation that should result in the negation of various pieces of legislation which have been enacted to give effect to the Constitution.
Yes.
The third issue we want to deal with relates to the attack on the cabinet approval, the parliamentary approval, and public participation. My lord,
Yes.
the transaction has been alleged to have been conducted secretly in an opaque manner and without the requisite adherence to the provisions specifically of Article 10 of the Constitution.
Yes.
Well, we have demonstrated in the 3 affidavits sworn by the Cabinet Secretary
Yes.
that a sessional paper and accompanying explanatory material went to the National Assembly subsequent to the cabinet approval. The Joint Committee of the National Assembly considered the sessional paper, undertook extensive public participation, and the National Assembly approved it by resolution.
Right.
We have set out, my lord, 78 stakeholder institutions were engaged. Public participation forums were held across more than 30 counties. 32 sittings considered the valuation, the identity of the purchaser, questions relating to employment, governance, competition, consumer protection, data sovereignty, and national security. It is not the law that every objector who presents his views must have those views embraced unconditionally. The test, and I need not remind your lordship, your ladyship, the test is one of reasonableness. We have given you the Supreme Court's decision on British American tobacco for the proposition that public participation must be real, not illusory, and must provide reasonable notice and reasonable opportunity. in our respectful submission, that threshold has been met.
Okay.
There have been allegations of fraud against Parliament. No particulars have been supplied. And those allegations have not been proven. It is not sufficient to place rhetoric before the court and make allegations of such a serious nature as fraud. Fraud, as we know, must be pleaded with particulars and must be proved.
John, you should be winding up, eh?
I am making progress towards winding up. Look. Let me next deal with the question of pricing and valuation. Because clearly, this is at the center of the petitioner's case. But it is also where the case is most ambitious, but least proven in our respectful view. What the petitioners ask this court to do is to sit as a valuation tribunal. This court is not a valuation tribunal, neither is it a valuation committee. The court's role is to assess the legality of the transaction based on the material placed before it. Mr. Lempar, to his credit, has looked at the share price this morning. He bought, oh, he's even bought the shares this morning. Congratulations.
Yes?
And referred you to Section 60 of the Evidence Act. I need not remind the court that the material time is December of 2025, when the transaction was contemplated and sought to be entered into by the government. Share pricing is dynamic. It is affected by numerous factors. And if the petitioners had not interfered with this transaction through the launching of this petition, to which they're perfectly entitled, this purchase price would have come in 6 months ago.
Yes?
So it is not sufficient to cite today's price and allege on that basis that there is an undervaluation. Neither is it sufficient to ask that one expert's opinion be preferred over the valuation commissioned and relied upon by the government. The court's role is to determine the legality of the sale, taking into consideration constitutional and legislative provisions. and to determine whether the price in the circumstances agreed by the government is so abnormally low as to point to perversity by government. In our respectful submission, the evidence placed before you by the Cabinet Secretary is to the effect that professional transaction advisors were engaged. They considered all the factors. They had consideration to the numerous valuation methodologies, and they advised the government on what they considered to be a reasonable price with a premium based on the identity of the share, the proposed purchaser. In our submission, that price does not disclose any illegality. We have placed before the court comparative jurisprudence, specifically the decision of the Supreme Court of India in Balco Employees Union versus Union of India for the proposition that the court does not determine whether the valuation committee's price was correct, but examines whether proper procedure was followed and whether the price was arbitrarily low and unacceptable. The petitioner's expert opinion is not proof of unconstitutionality. It is at most, your ladyships, my lords, a different professional opinion. Beyond offering his opinion on what the price ought to have been, Mr. Nyakera has proceeded on the assumption or on the theory, on the theory that the price would be higher if M-Pesa was to be carved out. But M-Pesa is part of Safaricom. It is a unified company. It is not being sold separately.
Yes.
And the suggestion, therefore, that a higher price would have been obtained is based on a faulty theory that we submit this court should reject. In the end, my lord, your ladyship, the petitioners have not proved an undervaluation. They have just proved that they would prefer a different model. That is not sufficient to override the cabinet approval and the National Assembly's approval, both of which are integral to Section 87A of the Public Finance Management Act. Lastly, let me deal with the issues relating to data sovereignty, national security, Articles 35 and 65, and the question of competition.
Yes.
All of these arguments, my lord, proceed on a mistaken basis that sovereignty, data protection, national security are preserved by shareholding. Look, the sale of these shares does not suddenly dissolve Kenyan municipal law. Sovereignty is exercised through law. Safaricom will continue to be subject to the Competition Act, to the Kenya Information and Communications Act, to the Data Protection Act, and to the license conditions imposed upon it by the various regulators. And this does not depend on its shareholding. In any event, the proposed purchaser of Vodafone Kenya Limited is a Kenyan incorporated company. Is a Kenyan taxpayer and is subject to Kenyan law. There is nothing in the law to suggest that the sale of these shares to Vodafone Kenya Limited and the reduction of government shareholding would suddenly diminish Safaricom's compliance with the myriad of statutes that this country now has to police the different aspects of our lives.
Yes.
The reliance on Article 65 is misconceived. It is about land holding. There is nothing about this case that relates to the sale or transfer of land. And the less I say about that, the better. In any event, foreign shareholding in listed companies is permitted by Kenyan law.
So now I think you should conclude, eh?
Yes, I'm concluding, my lord. You
Please conclude.
allowed the petitioners back and forth between their different counsel, and I'm just trying to wind up the 7 respondents that I present their combined case. My lord, in the end, when you break down the petitioner's case into its different components as a legal proposition, not as a political proposition, as a legal proposition, it is a disagreement about policy. It is a disagreement about the policy that government has chosen to follow with respect to revenue raising. No illegality has been demonstrated. Policy, my lord, is for the executive and the legislator. Legality is for the courts. Once you find, as I'm confident that you will, that no illegality has been shown or demonstrated, it will be clear that the prayers sought must be declined. We ask that you refuse those prayers and that you dismiss the petition. I must abide.
Okay, thank you very much, John.